Hi, Attorney Steve Vondran here again, licensed to practice law in California and Arizona, including all the federal courts in these states. So I want to talk in this video about federal court removal. Okay, so this is something that pops up quite a bit, and we see it in our real estate foreclosure, distressed property litigation, in state and federal courts, some of the California Homeowner Bill of Rights cases. We just had a recent case that was sought to be removed to federal court. And so I want to talk about it real quick because this is something that in my opinion, the financial institutions, the loan servicers, the securitized loan trustees, they like to get these cases removed to federal courts. And not just them, other large companies, I think, have a desire to be in federal court where you have federally appointed judges and they sit for life and so forth and so on. And some of the bigger law firms may be more well grounded in the federal rules of civil procedure than some of your other attorneys might be. So I think they think there's a tactical advantage to being in federal court. Sometimes there's case law that is, more on the side of basically procedural law being on the side of the defendant. So a lot of times they'll see an advantage to trying to take your case from state court to federal court. And I'll show you real quick. This is one of the guides you may see. One of the guides we rely on is, you can see there's a whole bunch of rules. This is a book one of 4, by the way. There's 4 of these books, so you get an idea of the procedural elements that can be required, the evidence rules, those kinds of things. So basically, let's talk about it, okay? So in your typical case, you're going to have a plaintiff that files a lawsuit. For example, we filed a lawsuit under the California Homeowner Bill of Rights in a superior court. Okay, say, for example, Los Angeles Superior Court. So you file that, and then the defendant says, well, we want to get it out of that court, and we want to get it over here to the federal court in the same area, but the closest federal court. We want to make this a federal case. Okay, you have to understand it's their right to seek to remove it, and what will happen in that case. Let's go to the Attorney Steve whiteboard on this one. Basically, when a party is seeking to remove, you see here you have the complaint. The complaint is being filed, and the complaint is going to allege various causes of action. Okay, so a complaint may ask for breach of contract, breach of fiduciary duty, fraud. It may be having Truth in Lending Act. It may have the Fair Debt Collection Practices Act violations. It may have a violation of RESPA, the Real Estate Settlement Procedures Act. So there's all kinds of different things that a complaint can allege. The plaintiff gets to allege whatever they want in the complaint. So you can have state law claims in there, you can have federal law claims in there. So anything that you see could be in the complaint. Now, the defendant, when they get that, when you serve them with your notice of summons and complaint, and they get that and they look it over, they basically have two ways to take this case from your state court, for example, Los Angeles Superior Court, San Francisco Superior Court, whatnot, and to remove it to federal court. 2 ways. Okay, let's talk about that. One, let's start with the bottom one here. Federal question. If your complaint alleges a federal cause of action, that gives the defendants immediate grounds to basically seek to have that removed to federal court. Okay, seek to remove it. Federal question. What's a federal question? Basically, anytime you're suing for a federal law or suing for rights under a federal law, rule, statute, that's grounds when the defendant may try to remove it on you. Okay, so in other words, if you're trying to stay in a state court, let's say you have a local real estate issue and you just want a local judge to get for you to get your best, fairest, honest response. If you're trying to do that, and you wouldn't want to allege your Truth in Lending violations, you wouldn't want to allege your RESPA violations, you wouldn't want to allege your Fair Debt Collection Practices violation. You may have them, but you don't want to allege them. If you do allege those, particularly in the area of banking and real estate litigation, you will see an attempt to have that removed under what they call federal question jurisdiction, federal question jurisdiction, because you have a federal issue at stake. Okay, so if you have that, if you allege a federal question, if you have that, they're going to seek removal. That's not to say they're going to, but they can. Let's put it that way. And if you've sued one or more defendants, let's say you've sued 3 different parties. You sued the securitized loan trustee, this loan servicer, and the foreclosure trustee. If you've sued all 3, all defendants must agree. All defendants must agree. Okay, so that's basically the rule. Now, to remove, they need to remove within 30 days. We'll come back to that in a second. The other way to seek a removal is what we call complete diversity. Okay, so in other words, if your plaintiff is from San Francisco and they're suing a defendant in Missouri, or a Delaware defendant, a New York defendant, a defendant from another state, you have citizens of 2 different states. That creates what we call diversity. Okay, and the general rule is the diversity must exist between your plaintiff and your defendant and all other defendants. So if you're naming 3 or 4 defendants, they all must be from different states aside from the plaintiff's state. So if the plaintiff's from California and you sue a defendant in Missouri, and 2 defendants in Missouri and 1 defendant in Nevada, and you sue another defendant in Washington, you have complete diversity because they're all different in different states from that of the plaintiff. So you have complete diversity. So diversity is the second way to remove the case from state court to federal court. Now, there is one little minor detail to removing on diversity grounds, and that is you have to show a $75,000 amount in controversy. This is an issue that gets litigated all the time. What's the amount in controversy? The plaintiff didn't ask for a specific sum of money, so what's at issue? And so lawyers tend to argue about this, but it's a big, important factor is you have complete diversity, $75,000, and the general rule is the amount demanded in the complaint controls. So if the plaintiff is asking for $50,000 and nothing more, then you may not be able to meet your diversity grounds to get into federal court. If the plaintiff is saying, I'm seeking $5 million, well, of course, you've just met your $75,000 amount in controversy requirement. So these are the 2 main ways, the only 2 ways to get into federal court is to have one of these issues, okay? So generally, let's go back to the service rules. If the defendant wants to remove your case from state court to federal court, they need to do so within 30 days of being served with the summons and complaint. 30 days is the key. Or if it pops up later, let's say you amend your complaint later into the proceeding and it raises a federal question, now by virtue of the fact that you have now added a federal claim, like a truth in lending claim, well, now you have created grounds for the removal, and that must be done within 1 year. So there's a 1-year time frame when the case first becomes removable. If you remove it within 30 days of when the case first becomes removable is another grounds. Again, the plaintiff in doing so will send a notice to the state court saying we are removing this. They will file their removal notice with the federal court, and they will attach their pleadings, their service, their process, any orders, anything that's been issued in the state court. The state court will close its file pending the outcome of that, because as we're going to talk about, you have 30 days to oppose and to make a legal challenge to that removal. As a plaintiff in the state court, you have the grounds to object within 30 days of that notice of, it's called a remand motion. So you have 30 days to file that. Remember, when the plaintiff, sometimes these defendants get tricky, they don't have grounds for removal. They're doing it hoping that you don't catch it. If they're filing these, if they're signed pursuant to Rule 11, Federal Rules of Civil Procedure, which is a certificate that this is well grounded, in good faith, it's not boilerplate, and that's something that you need to keep an eye on. You may need to litigate this issue. So if you're facing a improvident removal, if you need a federal court lawyer, real estate and business matters, give us a call. Attorney Steve Vonner, we're happy to look your case over and to provide you some advice on removal and whether or not you have grounds. For more information, go to askattorneysteve.com, and we look forward to working with you.